Hello everybody and welcome back to the Law of Contracts. In this video what we're going to do is take an introduction to the concept of consideration, which is the next major element that is required for our understanding of creating contracts, the creation of contracts, the formal different things that are necessary for a contract to exist. So, like I said, we're taking an introduction to the subject of consideration. This is actually the final part of our series of lessons on the subject of the creation of a contract. So, we've done a number of lessons on the idea of agreement. We've delineated that between the offer and the acceptance. We then spent a couple of lessons looking at arguably the least important, or one of the least important, or at least the least heavily litigated areas, which is, of course, an intention to create legal relations. And then finally, we're going to focus and spend quite a bit of time talking about consideration. This is the final element of a contract which is required to make it legally binding, for it to be a legally binding agreement. And so we'll take a brief introduction to the subject in this lesson and then start to dive into all of the very important factors and all of the very important considerations as time goes on in future lessons' time. So, as a basic introduction, consideration is required for the validity of a contract. And so if there is a contract without consideration, it will not be valid. It would be void or voidable. And as a result, or no, it would be void. It would have not existed in the first place. And as a result of which, we have to think about consideration in as much detail and with the same amount of veracity as we're talking about agreement and an intention to create legal relations. Simply put, consideration means that in order for a contract to be valid, there must be an exchange of items or commitments. There has to be a mutual exchange of items and commitments, i.e., you must be getting something in return for something else, or you must give in return of getting something. Whether that be items, like I said here, or commitments, whether it be if you're purchasing an item from a shop, you give money in return for said item. That is the consideration. Both people in the contract get something out of it, okay? Sometimes known as a quid pro quo, something for something else, okay? In English law, we do not recognize contracts which have one-sided commitments, which involve one-sided commitments. There is no recognition of a quote-unquote contract that has a one-sided commitment, where you just give something and you don't get anything in return, or you just receive something and don't have to give anything in return. These aren't contracts according to English law. An obligation can only be enforced if there is something which is going to be gained in return as consideration for the item or for the commitment that you are going to give yourself. That is what consideration fundamentally requires. The case of Curry and Misa from 1875 gives us a more formalist definition of consideration, the definition of which is only found in the case law, so this is just an example of a definition. The facts of this case are as follows. The defendant had purchased what are known as bills of exchange. These were essentially debt instruments in relation to corporate securities. There was an instruction to the defendant to make those payments to the bank of the claimant. This was because the merchant was indebted to them, and so they wanted the money to be transferred straight to them rather than having to go through the rigmarole of transferring it afterwards. When this debt was discovered by the defendant, it suggested to them that they were an unreliable trader, and so as a result of this newly found information, or this newly found implication, they instructed the bank not to acknowledge the check itself. The claimants would then seek to argue that a contract had actually existed between them and the defendant, the merchant and the defendant, should I say, and that this was, as a result of which, something that would have breached the contract in question. The claim was actually successful on the part of the claimant on the basis that there had existed a valid consideration in this particular contractual arrangement. Lord Justice Lush gives the following definition of consideration in this case. They say that, quote, a valuable consideration, in the sense of the law, may consist either of some right, interest, profit, or benefit accruing to one party, or some forbearance, detriment, or loss responsibility given, suffered, or undertaken by the other. This is the definition of consideration as per the case of Curry and Meiser, as cited in Finch and Fafinsky from 2017. A similar definition can be found in the 1915 case of Dunlop and Selfridge, where they say that, quote, an act of forbearance or the promise thereof is the price for which the promise of the other is brought, and the promise thus given for value is enforceable. These are two definitions of consideration. Simply put, it is something for something else. There is an obligation on the part of you to actually provide something to the other party in order to receive valid consideration, in order to receive whatever that other party is going to bring to you in the contract. Welcome back everybody to the Law of Contracts. We're continuing in this video talking about the idea of consideration, something that we introduced in the previous lesson and that we're going to spend some more time in this lesson unpacking in more detail. So as noted in the previous lesson, we took an introduction to the subject of consideration for the Law of Contracts. We examined a basic definition of consideration, and we also stated some of the early case law on the matter that really gave us something of a definition of consideration, given the fact that there is only a definition of consideration found in case law and nowhere else. And so, well, we can find it in textbooks, of course, but in terms of what consideration fundamentally means, you can really just understand consideration to be something for something else. English law does not recognize the existence of contracts that are one-sided in terms of obligations. So if I make a contract with somebody where I give them a watch, for example, and I do so without anything in return, then this would not be valid at law in England and Wales because there would be no consideration. I'd have to receive something in return for that watch in order for there to be valid consideration and therefore a valid contract. This lesson is going to explore in more detail some of the more important elements of consideration. We're going to talk about how the principle of consideration actually establishes the existence of a contractual arrangement, contractual relationship. So, fundamentally, the whole point and the whole concept of consideration provides that fundamentally if an individual has a promise made to them to provide or to perform some kind of action, they are only able to enforce that promise in English law if they themselves have also made a promise in return. We can have examples where people have made agreements between parties where there is only a one-sided number of obligations. That's perfectly fine, but that would not be a contract in English law, and it would therefore not be enforceable under breach. So the result is that there has to be something made in return in order for that person to actually enforce the obligation onto me as part of a contract. This is really where we get the general consideration that, the general principle that consideration moves from the promisee. What does this mean? Well, according to the case of Tweedle and Atkinson from 1861, we can understand the way in which consideration is illustrated. It must be something which comes from a party to the contract, and it can't come from a third party. So it must come from the person who is making the promise. It has to be, I promise you this thing in return for something else. It could be, like I said in the previous lesson, the purchase of an item. If I were to buy a phone off somebody, I would do so by giving them money, giving them an item in return for that property. There is something exchanged there. There is an exchange of things. Now, this thing could be an item, it could be an object, or it could be a service. It could be an obligation. Someone might pay me to clean their car, and that would result in an exchange of value, fundamentally. The value in the service, the car that is being cleaned, versus the value in the money, of course, the money that they use to pay me for that particular service. This case, the case of Tweedle and Atkinson, fundamentally illustrates the fact that consideration has to come from a party to the contract. It cannot come from a third party. It was a case which involved a wedding where the fathers of both the bride and the groom had made the joint decision that they were going to each contribute a lump sum to the groom. This seemingly was intended to be a legally binding contract, and they included a clause within the contract that allowed the groom to sue for breach in the event that one party did not pay this lump sum. So it was considered that there was definitely an intention on the part of the parties to create legal relations. When the father of the bride did not pay, the groom, as a result, sued as a result of this breach. The reason why this case would ultimately fail is because it did not adhere to the principle that consideration must flow from the promisee. It must flow from the person making the claim. The groom here was a third party. The groom had not made a promise in return for the lump sum that they were going to receive. In fact, it was the groom's father who had made that promise. There was an agreement between the bride's father and the groom's father, not between the bride's father and the groom. The groom represented in this case a third party. And so the result here is that because there was this principle that consideration must flow from the person making the claim, that person cannot have been the groom, therefore the groom could not have sued the bride's father for breach of contract. Welcome back, everybody, to our lessons on the law of contracts. In this video, we're continuing to talk about the creation of contracts, focusing specifically on this idea of consideration and focusing on the idea of past consideration. This is sort of going to be part of a broader conversation that we're having in relation to the various different types of consideration. We'll talk about the notion in continuation of the notion of consideration in the law of contracts in this video, and we're going to talk specifically about the idea of past consideration, or at least the rule against past consideration. You could even frame this argument or frame this legal principle as an idea relating to the temporal nature of consideration. There is a certain time element that is attached to an understanding of consideration for the purposes of contracts. What does this mean, therefore? Well, past consideration simply refers to the view that consideration cannot be given once an action has been performed. There is a certain time period that is required for consideration to have existed, and then if that action has been performed, then consideration can't be given once that action has been performed. It can't be past consideration. So let's, for example, think about this. If we were to have an agreement for you to do something for me, and once you have done that, I promise to give you some money in return. You cannot sue me for breach of contract if I fail, because this is an idea known as past consideration, because I gave the consideration only once you have performed the act. Okay, there has to be at least a certain amount of coincidence when it comes to the actions and or obligations that you are going to be exchanging. They have to coincide, at least to an extent, with each other. Okay, so you can't have a promise for someone to do something for me, and then so only if they do that promise, then the consideration exists. There has to also be the agreement that the promise is made to give me some money, and this would be in return for the action to do something. Okay, and so in this case, there would not be a contract. There wouldn't be a contract between me and you in this example, because consideration had been passed. It had not been done at the performance of the action in question. So yeah, we generally do not accept the existence of past consideration in English law. Let's look at some cases to illustrate this point. The case of Re McCardle from 1951 illustrates this point quite nicely. It was a case which involved a son and a wife who had lived in the house of his mother. Okay, so the mother was the mother of the son, and the daughter-in-law of the mother as well, the wife of the son. The wife had made a number of renovations to the property. So she had done a number of different things to the property to renovate it, to make it look a lot nicer, which the mother sought to have compensated. She did so by getting her other children to sign an agreement to pay her when the estate is sold. So the agreement essentially was, you've made these renovations, you've gone to quite a lot of cost and quite a lot of effort to do so. What I will do is I will say that you will be compensated when the estate is sold, okay? And I've got my children to sign an agreement to pay you for this compensation when the estate is sold. The estate was to be sold on the death of the mother. So when I die, this house is going to get sold, and you're going to get compensated for these renovations that you did. When the mother did die, the children then went back on their promise and refused to pay her for the renovations. Not particularly very nice, but when the wife sought to claim for a breach of contract, the claim failed, owing to the fact that the consideration that she had been given was past consideration. She had already performed the renovations, and so therefore, as a result of which, the subsequent pledge to pay her did not make for a legally binding agreement. It didn't make for consideration, okay? She had performed the renovations, and then only after the performance of the renovations, she had done her end of the virtual contract, if you will. The mother then said that they were going to make an obligation to have her be paid after the estate is sold. This is known as past consideration. Therefore, there was no contract, and therefore there could not have been a breach of said contract. Going all the way back to 1615, we have the case here of Lampley and Braithwaite. This case was one that gives us something of an exception to the past consideration rule. The rule that past consideration is not valid. This seems to challenge that perspective, at least in certain circumstances, that past consideration could still constitute validity for the purposes of the creation of a contract. It does so on the basis that if an act is requested, then there is an understanding that it will be rewarded. This constitutes valid consideration even if the performance is past. The case itself involved the defendant who had killed a man and who had sought to get a pardon by asking the claimant if he could obtain it for him. So, 1615, there was a likelihood chance that he would probably go to the death penalty as a result of being a murderer. He had killed a man and he wanted to get a pardon, and he asked the claimant for a pardon. The claimant went about an arduous process, which was costly to himself, but was told that he would be rewarded if he did. This reward never came. The claimant then sued the defendant as a result of this. The efforts that the claimant had gone to were in relation to the promise which was made on the part of the defendant to reward him had he been successful in securing the pardon. And so the result of all of this was that even if the performance was technically past, it was done so on the basis that the act was going to be rewarded. So he had only performed the action of going through the arduous task of trying to get a pardon because he was told, hey, if you do so, I will reward you as a result. So therefore, consideration, even though performance had been past, consideration had not been. Welcome back, everybody, to the law of contracts. We're continuing talking about the idea of consideration in this video, asking the question of what constitutes sufficient consideration, and what the difference is between adequate and sufficient consideration for the purposes of establishing a contractual arrangement. So really, what steps do we have to go to? We will discuss the comparison and the meaning of the comparison between the idea of sufficient consideration on the one hand and adequate consideration on the other, what these things actually fundamentally mean, and whether or not these things have a meaningful difference when we actually start to talk about the law itself. So, the general rule for the courts is that consideration at issue in the contract be sufficient to render the promise enforceable. It's as simple as that. In order for there to be consideration that renders a promise enforceable, that consideration has to be sufficient. There has to be a certain sufficiency established in it. And this is, as a result of which, means that the role of adequacy is not present in any kind of understanding of consideration. This does not place adequacy requirement on the issue of consideration. So, in fact, so long as the promise is enforceable, the consideration will be valid. And this is even the case if the courts or even the general public may suggest that the consideration did not represent a fair deal. So one of the things that should be noted is that consideration is, of course, something for something else, is an exchange of promises, but those promises don't need to be equal on either side. It doesn't have to be the case that the deal is fair. We could all come to the conclusion that, in fact, it's not a fair deal at all, that this person has been swindled by the other person. But whereas that might represent something of an injustice in terms of being able to establish a fair deal, it doesn't make anything or speak anything to the question of whether or not there was consideration, and whether or not, as a result of which, the promise is therefore enforceable. There is nothing unlawful about making a contract which represents an unfair bargain. You could theoretically sell a car for a £10 note. That's not necessarily suggesting that the deal is fair, because of course the value of a car is much higher than that of a £10, but it still represents something of a consideration. An illustration of this is the 1842 case of Thomas and Thomas. In this case, the issue of sufficient consideration and then the central question of whether or not the promise was enforceable came to head in the dispute. At the death of a husband, it was made clear that he wanted his wife to be able to freely live and stay in the house that they had owned. However, this was not something that was clearly stated in the will, so the executors of the will suggested that she be allowed to stay if she paid rent of £1 per year. Okay, not much money for even 1800 standards, definitely not much money in terms of today's standard. If you can get rent for £1 a year, then you are in a really good deal. When it was attempted to dispossess her, the question of whether or not this amounted to consideration and therefore was enforceable was a question that came to the court, because it seemed to be the case that it was so unbelievably unbalanced that the rent that she would pay is £1 a year, that it meant that surely this can't represent consideration for the enforceability of a contract. Well, the courts held that the wish of the husband in and of itself would not have been sufficient to amount to consideration. So just having the death of the husband and making it clear he wanted his wife to be able to live there, that wasn't enough in and of itself to amount to a sufficient amount of consideration. However, even though it wasn't an adequate amount of consideration, given the fact that it was an unfair deal, given that she was only paying £1 a year for rent, the payment of £1 a year was nevertheless sufficient to enforce the contract, because it was sufficient consideration. And so the question of consideration, generally speaking, is that it will have to represent some kind of tangible piece of real value. It has to have some kind of value attached to it. But the amount of value doesn't seem to be something that is much of an issue here. Like I said, you could buy a car for a £10, and even though it doesn't seem to be a fair deal, it is still real value. £10 it still has value in the world. It just doesn't have enough value to be an equally fair deal given the market prices of cars today. Similarly, £1 a year in rent, again, isn't a fair deal, but it is still real value. A pound is still something of real value. It's tangible, okay? The amount of value relates to the adequacy of the consideration. And so really the question of how much value we are adding or how much value we are giving in terms of consideration is a question of adequacy, which, as we've noted, is not relevant for the purposes of just establishing a consideration. If I were to contract with you and to purchase a very expensive diamond ring, and we were to agree to an asking price of £1.50, this would definitely not be adequate consideration. It would not represent the true worth of the product. It could be thousands in reality. But if it was agreed by the parties, it will be sufficient. And given the fact that £1.50, despite not being very much value, is still a tangible piece of value, it would suggest that therefore it was enough for sufficient consideration. Another example of this case is in the specific case of Chappell and Co. versus Nestle from 1960. It was another case which represented this idea of so-called nominal consideration. The claimants in this case had been the defendants, had been the owners of the copyright of a song. The song was called Rockin' Shoes, okay? The defendants sought to use this copyright with their permission and so offered to purchase it for 1 shilling and 6 dimes and 3 chocolate bar wrappers, okay? A very nominal amount of consideration, a very what would seemingly be a very inadequate amount of consideration. Because the record itself, even though it was purchased for the price of 1 shilling and 6 dimes and 3 chocolate bar wrappers, the record itself would sell at a price of 6 shillings and 8 dimes, so quite significantly more than what was originally bought for. The question for us was whether or not the 3 chocolate bar wrappers would represent sufficient consideration, despite the fact that they had no value to the claimants and had been thrown away immediately. Okay, obviously we know that it wouldn't have been adequate consideration, it wouldn't have represented a fair deal, but was it sufficient to even establish the existence of consideration? It was held by the courts that they were, and they said the following. They said that it is said that when received, the wrappers are of no value to Nestle. This is irrelevant. A contracting party can stipulate for what consideration he chooses. A peppercorn does not cease to be good consideration if it is established that the promisee does not like pepper and will throw it away. Okay? This is a very important point, because it suggests here that the tangibility of value in relation to consideration being sufficient is something that is not subjective. Okay, just because to Nestle 3 chocolate bar wrappers has no value to them does not mean that it doesn't objectively have no value tangibly whatsoever. And so the question of whether or not they had value to Nestle was an irrelevant point of fact. And the analogy used of peppercorns being thrown away because the promisee doesn't like pepper does not mean, therefore, that pepper has objectively got no value or peppercorns have no value. And so the result of this is that anything that is tangible in terms of value can represent consideration. And even if, like it says here, they had no value to the particular person in question, is irrelevant. And what is interesting here is that a contracting party could stipulate for what consideration he chooses. So if they suggest upon the creation of a contract that they want a specific type of consideration, a specific amount of consideration, then this would be considered as part of the establishment of sufficient consideration for the purposes of a dispute. Welcome back, everybody, to our conversation on the issue of consideration. Now, we've been focusing over the last few lessons on various different elements of the law relating to consideration. And this lesson is going to talk about the concept of existing consideration. So, fundamentally, the question that is asked is, to what extent could some existing obligation represent a form of new consideration in the creation of a contract? Does this automatically represent a sufficient amount of consideration for the purposes of creating a contract? Now, when we think about what consideration actually is and how it works, we know that the element of consideration that is something that we think about is that consideration ought to represent some kind of detriment or forbearance. What we mean by this is that when we are doing consideration, it's an exchange of promises, either to give something or a promise to do something for some other individual. If I purchase something from a shop, okay, then the consideration that is here is that the person who owns the shop is giving me some item of value, and I am doing so in exchange for money. Now, this represents a detriment. I am losing money in the gaining of this thing that I want to buy. I have to give up some of my money to do so. That's what we mean by some kind of detriment or forbearance, something that it is depriving you of something that you have, whether that be some kind of money, if it's an object that you are giving over, or even in some cases, whether it's your time and your energy in terms of performing some kind of service. With this in mind, therefore, when it comes to the performance of an existing action, i.e. something that you are already doing, then this does not usually amount to sufficient consideration for a new promise. So if we are thinking about creating a new contract and we're thinking about the consideration for that new contract, if I say, well, I'm for my consideration for my end of the bargain, if you will, what I'm going to do is continue to do the thing that I'm already doing. This usually does not amount to sufficient consideration for a new contract if I was just going to carry on what I was doing. When we think about new consideration, sufficient consideration for a new promise, we have to think about a new detriment and a new forbearance in relation to the action that we are performing. The courts have also held that the performance of a duty for which you are statutorily obliged to do also cannot amount to a new consideration. So if you were under a duty to perform an action anyway, under, for example, statute, then that cannot represent consideration, because while it is a detriment to an extent or a forbearance, it is still something that you would have been required to do regardless of whether or not a contract was in place or whether it was not in place. And to illustrate these points, let's look at a couple of cases. The case here of Collins and Godefroy from 1831. This case involved a court proceeding where the claimant was called by subpoena to give evidence. They were subpoenaed, so they were under an obligation to go and give evidence. An agreement was made between the claimant and the defendant in this case, who was also the defendant in this case that we're talking about here, that he would give evidence in court. He believed that because he believed that this would be useful to his case. When the claimant turned up to court, but was never called upon to give his evidence, he requested payment for which the defendant refused. So we have a couple of points here. So they made an agreement, a contractual agreement, or at least on the part of the claimant, they argued it was a contractual agreement, that if you come and give evidence in court, I'll pay you some money. This is because the defendant believed that, well, if this person gives evidence in court, then that's going to look favourably on my defence. When it turned out that the court never called upon him to give evidence, he still requested the payment because he's turned up to court. But the defendant responded by saying, well, no, not only is there not a contract here, but you didn't fulfill your obligation of giving evidence. The main issue here, though, was whether or not there was a valid claim for breach, in the case that he had made an agreement with the defendant to turn up and give evidence. Now, it was held that there was not a valid claim for breach because of the fact that he was called by subpoena to give evidence in the first place. And so, even though you would represent this as valid consideration to an extent, given the fact that this was a forbearance in return for some money, it was a performance of an action in return of some money, the performance of the action was made statutorily obligated, statutorily obliged to do, on the basis of the fact that there was a subpoena that provided him with the opportunity to come and give evidence. So, if there was no subpoena, then this could have been a successful claim. But the fact that there was a subpoena suggests that there was a duty on the part of the claimant to actually come and do the performance of the action anyway. So this cannot represent valid consideration. Another case which takes place in 1809 is the case of Stilk and Myrick. Now, this case, there were a number of sailors who had been contracted to crew a ship from London to the Baltic Seas, and then to return back to London. Now, the conditions were particularly harsh, and 2 of the 11 would actually desert their posts along the journey. The rest would refuse to work until they were promised to have higher wages. They continued their work when these wages were promised by the captain. When they got back to London, the captain basically stiffed them and said, we're refusing to pay those higher wages. The result was that the crew suggested that this was a contract that the captain had then been in breach of. All of their claims would fail, given the fact that they had already been contracted to sail the ship from London to the Baltic and back. An additional promise could not be enforceable, therefore, the additional promise of having higher wages, because there was not an addition of consideration. They were already contracted to do this voyage, and so even though the conditions were particularly harsh and they were probably more than they expected them to be, it still didn't mean that this was representative of new consideration. We're going to get to another case in the future where a very similar thing happens in terms of the requesting of higher wages that actually is successful. But the distinction here between this case and the case that we'll look at in the future in a couple of lessons' time is representative by the fact that there were a significant number more desertees in the next case, which actually did mean that the job was significantly different compared to in this case, where 2 of the 11 being deserting from their posts did not represent new consideration. In the previous lesson, we discussed the question of existing consideration, noting that if you are already performing some action, or there is already some kind of detriment or forbearance that you are engaged with, this cannot represent a new form of consideration for a new agreement. There has to be some additional thing that takes place. This is the general rule for existing consideration. However, there is also exceptions to this general rule, and we'll talk about these exceptions in this lesson when we talk about this idea of exceeding consideration. So we noted that, for example, the existing duty to perform some action can never amount to a new consideration for a new promise. This is the general rule. We also noted that a statutory duty to perform some action, such as a subpoena, cannot also represent new consideration for a new promise. This is true and is the applied general rule. But exceptions to this rule do exist. The most important of these exceptions is this idea whereby an individual is actually exceeding their ordinary amount of consideration for their original promise. This exceeding of consideration can represent a new form of consideration for a new contract. And we'll talk about how this can actually amount to new consideration in this lesson. So that was the general rule. If you have already contracted to do something, and you have therefore got consideration on the part of or at least you have agreed on the consideration, and then you perform that duty. Okay, the existence of that duty does not mean that you can't. Does mean that you essentially cannot. You cannot require that a new agreement be valid on the basis of the consideration that you're already doing. It cannot represent new consideration. However, fundamentally, if there exists some statutory or contractual duty that must be performed, this normally cannot amount to new consideration. That's the general rule. However, if one goes beyond and performs more than this statutory or contractual duty obliges them to do so, this additional performance can amount to a new form of consideration. And then there are 2 cases that illustrate this point very, very nicely. Exceeding of contractual duty of statutory duties on the one hand, and then exceeding on contractual duties on the other hand. So the first here talks about the exceeding of a statutory duty, the 1925 case of Glassbrook Brothers Limited versus Glamorgan County Council. The facts of this case take place during a miners' strike. The Glamorgan County Council had agreed with the defendants that they would provide an additional 70 policemen at the colliery of the defendant if they would return this favour with some kind of payment. When the defendants refused to pay, they sued for the breach of contract. The issue here, however, was that there was a statutory duty on the part of the county council to provide the defendants with policemen at the issuance of strike action. So where there is some kind of strike, such as a miners' strike, the county council has a duty to provide police, and this is a statutory duty on the part of the public authority. So the argument here was that the adding of policemen or the issuance of policemen does not represent consideration, given the fact that, according to the general rule, this is the statutory duty that the council had to do. So this, in return for some payment, was not contractually obliged. Theoretically, however, what the county council argued was that while there is a statutory duty to provide police officers during some kind of strike action, such as a miners' strike, they had actually exceeded their statutory duty by saying that they were going to provide an additional 70 police officers. And so by providing so many, this had gone beyond what would reasonably be considered to be the statutory duty of the public authority. This additional providing of, or the additional provision of more police officers, therefore represented a new consideration for a new agreement, and so therefore the contract was valid. Now, it was a close decision in the House of Lords. It was a 3-2 decision, but they did hold that going beyond the statutory duty does actually confer sufficient consideration to establish a new contract. So the giving or the providing of police officers in and of itself is a statutory duty, and so would not have represented consideration for this contract. But the providing of so many police officers exceeding their statutory duty would have provided the necessary consideration to establish a contract. So essentially, it was held that the defendant requested services which went beyond the statutory duty of the council and the police. And it establishes the view that the additional detriment in providing more than the statute obliges creates this new consideration. So this is an example of exceeding a statutory duty which gives rise to new consideration. What about the exceeding of contractual duties which gives rise to new consideration? Well, this is a case that I talked about at the end of the last lesson, the case of Hartley and Ponsonby from 1857. This was another case which involved sailors trying to get more out of their captain midway through a voyage. So the previous case of Stilk and Myrick was a case where they had gone to the Baltics and come back again to London, and 2 of the 11 crew deserted. The conditions were harsh, and the captain refused to pay them this additional amount of money in return for their essentially finishing the voyage. And it was argued in that case that they had already contracted to go on this voyage, and so they cannot have gone and used the same consideration to create a new contractual agreement. This case is a little bit different. The main difference here is that the remaining sailors were promised additional pay if they took up the work of a number of deserted members. So a number of people had deserted on this voyage as well. However, where the case of Stilk and Myrick, there were only 2 of 11 crew deserting, in this case 17 had deserted. So quite a significant number more people had deserted, which changed quite significantly the nature of the job for the remaining sailors. It was held that the promise made by the captain was enforceable, owing to the fact that, given such a reduction in the crew, and given such a change in the nature of the work that had been performed, the returning home was far more dangerous and required far more additional work from the remaining crew, given the fact that 17 had deserted, quite a significant number. And so this meant that they had gone beyond their contractual obligations by not only performing what the contract told them to do, but performing more than they were obliged to do under that contract, owing to the fact that there were 16 desertions. And so the result was, as a result of this, that this represented new consideration and therefore made the promise enforceable on the part of the captain.